Good afternoon, everybody. Welcome to our first CLE for 2022 on intestate probates called Wills. We don't need any stinking wills. My name is Kristen Solis. I am one of the mentor attorneys of the Dallas Volunteer Attorney Program. And for those of you that are not familiar with DVAP, as we affectionately call it, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys who will do their civil cases pro bono. One of the biggest needs that we are getting right now are probates. We are seeing more and more people pass away, a lot of them from COVID, especially without wills, and they are desperately needing attorneys to help them with their intestate cases to, get access to a house or a bank account, whatever the issue is. So we are desperately in need of folks to sign up to take those types of probates. Our speaker today is Jack Wilburn. Jack is a sole practitioner in Carrollton who practices in probate, guardianship, and estate planning. Jack has his BA in music from McMurray University, Abilene, and got his JD from the University of Houston. He's a former intern of Judge Nikki DeShazo, who was a former probate judge in Dallas here that we all knew and loved. And Jack is the past chair of the Dallas probate section. He is a wonderful resource and the guy I always go to when I have all my questions about probates. And as we go along in the presentation, if you have any questions, put them in the Q&A section and we will try to get to them. And without further ado, I'll turn it over to Jack.
Thank you, Kristen. Welcome, everybody. If you have previously participated in something that has affectionately been termed the probate plumber, this is a very similar talk and presentation, but we've now revamped it to wills. We don't need no stinking wills. And depending on when you grew up, you either think that's a line from Blazing Saddles, or actually that is a takeoff or a parody from the actual movie, which is The Treasure of Sierra Madre. So, and if you've ever seen me speak, you're stuck with a joke at the beginning. So without further ado, the 2022 presentation joke by Jack Wilburn, stolen from the internet this morning. So a guy dies and promptly arrives at the gates of hell, and shocked where he is, he immediately goes to the devil and says, hey, there's been some sort of mistake here. I don't think I'm supposed to be here. And the devil says, well, sometimes mistakes happen. There's a lot of people that die and mistakes happen. So tell me, what were you doing when you died? And the guy says, well, I had taken my grandchildren out for a lovely day, and we were enjoying ourselves when all of a sudden a giant mouse came charging out of nowhere. And you would not believe the size of this mouse. It was huge, and it was charging at us. And not knowing if it was rabid or if it might hurt the grandchildren, I began to beat it with my walking stick. And I beat it until it was dead. And the devil said, so you killed it? And the guy said, well, it never got up, so I assume I killed it. And the devil says, God, that's not really the sort of thing that lands people down here. So let me make a quick call. All right. So he calls upstairs. Hey, Jesus, I think we may have a mistake. I've got this guy down here. And so the devil tells him the story. And, the guy's just sitting there watching as they're talking on the phone. The devil's, well, okay. And then the devil puts his hand over the receiver. I guess they still have old technology down in hell. And he says, sir, I I think we've got this all worked out and it's just a misunderstanding, but we do need some clarification on one thing. Where were you when this happened? And the guy says, oh, Disneyland. So I'm assuming everybody just fell out of their chair laughing because I can't see anybody. I can't hear anybody. That's the good and bad of doing these presentations over Zoom. I get to assume the best and negate the worst. So everybody was laughing, guffawing, slapping their knee, spitting coffee on their computer screen. So thank you very much. So why are we here? We're here to talk about what happens when somebody dies without a will. And because this is a DVAP presentation, I will try to direct it to what you can do if you take a DVAP case and these facts appear. I will say, generally DVAP doesn't get involved in contested matters. So sometimes these matters do get contested and they get referred out, or people have to go hire private lawyers. But for the most part, just because a DVAP client is coming to you and there is no will doesn't mean that you can't help them. So here we go. Let me try this again. There we go. So how often does this happen? How often do people die without a will? Well, some reports show that as many as 70% of Americans die without a will. That means, most of the time when you're meeting with somebody, there was no will. And so you got to know how to deal with this. So when they say, somebody sits down with you, generally my first question is, did they have a will? And when the answer is no, then I immediately start having questions. And this is, your best friend is just asking questions and listening, because depending on what kind of assets the person had when they died and how they were held will tell us what we need to do. So it's very important that you have a great intake interview, that you ask the right questions and you understand as best you can, understanding that it's coming from somebody who may not have all the facts at their disposal as well, but it's super important to try to get these questions out. So ask questions about the assets and how they were held. Did they own a home? Were they renting? Did they own a car? Were they leasing? Did they have bank accounts? How were those bank accounts titled? Were they solely in the name of the decedent? Was the decedent married? Were those joint accounts? Were those joint tenants with right of survivorship accounts? Did they have retirement accounts? Did those accounts have beneficiaries? Who do we think the heirs are of these assets? And it's possible that all the assets are what we call non-probate, and there's no necessity to go through probate at all. So for example, someone comes in, the decedent was renting an apartment, had minimal personal property, and they had a bank account that was either joint tenants with right of survivorship with someone, or had a beneficiary designation, a POD, a payable on death beneficiary listed, and that was it. Well, then there's really nothing the court needs to do. The court does not need to be involved in that. Those assets, that that bank account can transfer to the joint tenant upon presentation of a death certificate. And generally speaking, if we're talking about minimal personal property and there are no disagreements, we can get that stuff donated, given away, and avoid the necessity of spending money down at the courthouse and clogging up the courts with that. If the assets they held were in trust, or I guess they wouldn't hold them, if the assets that they're telling you about are in a trust, that's a non-probate asset. The court's not really going to have much to do with that. You just have to get your hands on a copy of the trust, make sure that there's a trustee in place and that the assets were actually transferred into the trust. I don't know how many times you've sat down with someone and they come in with a binder that thick that they tell you the decedent paid $10,000 for, and there's no assets in it because nobody transferred any assets into the trust. And oops, there's a draft of a pour over will, but it was never signed. So, but if all of that got done and the assets are solely held by the trust, then that's non-probate and you don't have any issues. Again, bank accounts, joint tenants with right of survivorship, payable on death, beneficiary designation, anything like that can keep us out of the courtroom and get these assets transferred to their transfer owner and get them moving on down the road. Retirement accounts, IRAs, again, beneficiary designations. I'll also tell you this, there was a time when I believed that it was all about the beneficiary designation. Depending on what it is and where it was created, it may pass under the terms of the contract. This happens a lot with employee benefits. And the rules of intestacy don't necessarily apply. They've drafted their own into the agreement, and it doesn't matter what you think, it matters what the company thinks. So it's going to transfer per the terms of that agreement. But again, possibly not a probate asset. Even if they have vehicles, if there is a transfer on death part of a car title that could have been filled out, there's also an affidavit of airship that can be completed with the DMV and transfer assets without the necessity of letters, either letters testamentary or letters of independent administration. So again, depending on what someone owned and how they owned it, you may not need to involve the court at all. And let me tell you, one of the coolest things is somebody comes in, they're freaked out. As I like to say, nobody calls me when anything good has happened. Somebody's died, somebody's lost capacity, there's some problem. And it's really neat to sit down with somebody who is just freaked out and overwhelmed, spend a little bit of time with them asking questions, and then getting to say, you know what, you don't need me, you don't need a lawyer, and have them go on with a plan to have those assets transferred without needing to pay a lawyer a bunch of money. That's about the favorite part of my job. So, however, if the answers to those questions do not lead you to the conclusion that, oh, well, these are all non-probates and you don't need anything from me and there's really nothing I can do for you, and here's a list of things you need to do and it was nice to meet you. If that's not the case, then you got to start looking at your toolbox or your arsenal and see what you have at your disposal to help someone. So again, you've asked lots of detailed questions, and once you ask all those questions, you'll be able to apply these techniques for handling intestacy.
Hey, Jack.
Yep.
I'm going to jump in. We have a question before you get onto that. So when there's a vehicle and you're talking about the affidavit that you file with the DMV, do you do that before or after the death?
So yes and yes. So if it's on the title, there's literally a place on the car title where the person who owns the car can fill out a transfer on death to whoever they want the car to go to while they're still living. Now, if they didn't do that and they've died, there's a form at the DMV called an Affidavit of Airship where you can, after they've died, use the Affidavit of Airship. So the transfer on death that's embedded in the actual title is a pre-death, and the affidavit of airship is a post-death. So Kristen disappeared on me, so I assume that answered the question. All right, so here's our techniques for handling intestacy. We have a determination of airship, and don't worry, we're going to come back and cover all of these in detail. But we have the determination of airship that's going to be found in Texas Estates Code Chapter 202. We have what's called a court-created independent administration, which is under Estates Code 401.003. We have a dependent administration, which is 306.002 sub 1. We have the Affidavit of Airship, which is 201.053. We have the Small Estate Affidavit, which is Estates Code section 205. We have what's called a Determination of Airship and Order of No Administration under section 451 of the Estates Code. We have an application for family allowance and order of no administration also under 451. We have administration of community property under 453. And we have, you can obtain access to an account with a financial institution under 153. So that's quite a list. And what I love about this is there's pretty much nothing you can't do for somebody who walks in your office without a will with this list. You can cover everything. Now, that list, it ranges from super easy, super cheap to super complicated, super expensive. And so I'm always trying to find the cheapest, easiest way to help somebody to get the help they need and move on down the road and avoid what I call scab picking, which is my way of referring to something that's keeping them from getting to closure. If I can get them something that's going to get them started on the road to closure for the loss of their loved one within a couple of weeks, as opposed to a drawn out dependent administration with a contested airship that draws out for a couple of years, that's just scab picking, and that keeps them from getting to the closure they're looking for. So let's start with the determination of airship. Now, you hear all the time that if someone dies without a will, that everything they have is going to the state. I hate that saying. I hate when people say it. We all know, or you're about to know if you don't know this, that the state has a will for you, and it's called intestacy. And where those intestate assets go to is determined by who the heirs are. And the heirs are just the people that were related to the decedent when they died. So a determination of heirship is a judicial proceeding of who the heirs of the estate are. You're literally going to get an order or a judgment saying who the heirs are. Now, here's the downside. In every county I practice in, well, I take that back. In a couple of the counties I practice in, you have to automatically deposit a $500 deposit for an attorney ad litem for unknown heirs that's going to be appointed. No matter what, whether you put the money up front or you have to pay the money later, it's about a $500 to $700 expense no matter what for this extra attorney. But it is what it is, and you're going to have to pay it. So you're going to pay that ad litem fee. You're going to, when you get to a hearing, you're going to need to have what we call disinterested witnesses. So let me back up a minute. So your determination of heirship, or your application for determination of heirship, just lays out the facts about the decedent. So I'll do me because I know me. And by the way, I have a will, but let's pretend I don't. If I was to die without a will, first of all, my wife would resurrect me and then kill me for dying without a will. But the application for determination of heirship would lay out that I died on such and such a day. And at the time of my death, I was married, and I had only been married once during my lifetime. And during our marriage, there were born 2 children, and I didn't adopt any other children during my lifetime. So my heirs would be my wife and my 2 kids. And depending on what kind of property I own, if it's community or separate, it depends on who gets it. And then my wife would have to find 2 people that are not her or my 2 kids to come in and testify that those are the facts. So, she'd grab my sister and my best friend, and they'd come in and say, yeah, we've known Jack his entire life, and he was only married once. and he was married at the time of his death. And during that marriage, there were 2 children born to that marriage. And, that the heirs are his wife and his 2 kids. So sometimes it's easy to find disinterested witnesses. Sometimes it's not so easy to find disinterested witnesses. And here's my definition of disinterested. Somebody who's not taking from the estate, meaning they're not getting a dime of the money. And I take the position, well, because it's the law, inherited property is separate property. Because inherited property is separate property, an heir's spouse could be considered disinterested. This is a sliding gray scale of who else you've got available. But in a pinch, a spouse of an heir could testify as a disinterested witness. You also have to give citation to all of the heirs. Now, generally speaking, a normal determination of heirship that comes into my office looks like a second to die spouse with kids, or a step parent that dies with kids that aren't of the marriage. So sometimes this can be a little convoluted and a little difficult, but the bottom line is you just have to give citation. You have to prove to the court that you gave citation to each alleged heir, or those alleged heirs can file a waiver. Sometimes waivers are easier. Sometimes citation is easier. It just depends on your specific facts. But no matter what, the court wants to know, does everybody that is an alleged heir, do they know this is going on, and do they know about this proceeding? Sorry, that's that. And this can be a standalone thing. A determination of heirship can be a standalone thing. But most of the time, a determination of heirship is paired with a application for a court-created independent administration. And basically that is, so think about this in terms of if somebody did have a will. If somebody dies with a will, they name their own independent executor, and letters testamentary are issued to that person. Well, just because they died without a will doesn't necessarily mean that there's not a necessity for administration. Remember, we ask them all those questions up front, and we've learned that, dadgummit, there's assets that require letters to obtain, and there's a necessity for administration here. But there's no will naming an independent executor. So, hey, judge, will you appoint an independent administrator? The difference between an executor and an administrator: an executor is named in a will, an administrator is not. So they do the same thing. But once you determine that you have a necessity for administration, you're going to have to file these. And I generally file them as a combo. I file them as a combination application for determination of heirship and appointment of independent administrator. Now, here's the kicker. All of the heirs have to agree to the independent administration. All of the heirs have to agree. Now, okay, easy enough. That's easy enough. Now, what if those heirs are minors? Some judges say there's no way I'm appointing an independent administrator when there are minor heirs. Some judges don't have a problem with it. You just have to know what court you're in to know whether or not this is even an option. So when you're asking those questions at the initial meeting and you say, well, who do we think the heirs are? Well, he's got 3 minor children, and you're in Denton County or Dallas County, I wouldn't even bother with this. You're not going to get it, in my experience. So footnote or disclaimer, this is all experiential. This is what I've experienced. This is what I've learned from talking to my colleagues and listening to judges talk, that in those 2 counties, an independent will not be granted when there are minor children. So when you, yes, I see a question here. By the time we're done, so the question is, what's the difference between an affidavit of airship and a determination of airship? I think by the time we get done, that'll get answered. So, but thank you for bringing that up. I'll make sure I point it out when we get to it. So once, now I've lost my train of thought, which was not difficult to do. I was talking about the minor errors. If you know you're not going to get it, don't even try. We'll talk about a dependent administration here in a second. But if you're in a situation where all of the heirs can agree and will agree, they can execute what I call a designation, consent, and waiver. And it basically is a document that says, hey, I know that Bob died. I know that Bob did not leave a will, and I know that Jim is asking to be the independent administrator. I'm cool with that. What I'm signing here today is telling the court that I'm cool with that. I'm waiving citation. And here's a little pro tip. It's a little more advanced. But if you're trying to do an independent administration and there's real property involved, I put in my designation, consent, and waiver that the heir consents to the sale of real property. And then I have that language also included in the order appointing the independent administrator. And it avoids a lot of trouble down the road when you get to the title company. And it will give that independent administrator the authority to sell real property. So just tuck that away for later. But once all your heirs have agreed, most courts will not appoint an independent administrator unless you're also doing a determination of heirship, because how do you know if all the heirs agreed if you don't determine the heirs? So that's why we do them together. Now, the other thing that can happen here is the heirs can waive the bond. In most wills, when somebody is appointing an independent executor, they say, I appoint my, so-and-so to serve as independent executor to serve without bond. And so this is just a way to accomplish that same thing. We're going to put it in the designation, consent, and waiver that I am an heir. I know that Jim wants to be the administrator, and I want him to serve, and I want him to serve without bond. And generally, the court will waive it if all the heirs agree. As I said, most courts will not create an independent administration when there is a minor heir. Depending on what court you're in, you may get a different answer. Now, here's the deal with an independent. It's independent. It's not dependent. Well, what does that mean? Well, there is no court oversight. Once those letters of independent administration are issued and that independent administrator files their inventory, the court's done with them. There's no coming back to the court asking permission to do anything. And so there's not a check and balance here to keep your administrator in check when they're independent. It is a great tool. It is a fabulous tool, but you better trust the person you're appointing as an independent administrator. And so because it is independent and it doesn't involve the court and going to court to ask permission for every little thing, it's cost effective. It's much cheaper than a dependent administration. Now, let's talk about a dependent. You can also team this up with a determination of heirship. So you've talked to your client, you know there's no will, you know you need an administration, you know you need a determination of heirship, but they've already told you, look, I don't care what happens. My cousin Susie or my sister Susie is not going to agree to me being independent, and she's not going to agree to anybody being independent. She just won't agree to nothing. Okay, well, you can't push a rope, as I like to say. So you just deal with the facts as they are. So you're going to pursue a dependent administration. So a dependent administration does not require the agreement of the heirs. So, and oh, by the way, if there are minor heirs, this is the way you're going to go in a court that doesn't appoint independent administrators for minor heirs. So again, the courts may require a simultaneous determination of heirship. That is becoming more and more prevalent. When I first started practicing, oh my God, almost 20 years ago, the courts seemed to be more likely to appoint just what I would call a naked dependent administration with no heirs determined, and then you could figure out the heirs later. And I've made arguments even recently with judges that say, you know, yes, there are heirs. We need a dependent, but we're not 100% sure that there's enough assets that are even going to survive this administration to go to the heirs. And so I'll ask to forego the determination of heirship until we get a better handle on what those assets are. Again, check your local listings. Some judges might buy that, some might not. You may be stuck doing both, and that's fine. As I was taught many years ago, each court is its own kingdom, and they can do whatever they want with these types of things. And so I just figure out what it is they're looking for, and I go do it instead of spending a bunch of time arguing with them. So you may be required to do a simultaneous determination of heirship. With a dependent administration, a bond is required. You have to bond for all of the liquid assets. You don't have to bond for the house, but if there's, or dirt. So if there's land and a house, that doesn't need to be bonded for. But if there's vehicles or cash or personal property or anything like that, you're going to have to bond for that. So you got to make sure that your client is bondable. And my pro tip there is right out of the gate, get them an application for a bond and get it sent over to your bond company and see if you can get them pre-approved for what you think is going to be the bond level. There's really nothing worse than jumping through all of these hoops, getting your client appointed after the hearing, then submitting the application and being told, you know, by the bond company, yeah, we can't get your client approved for a bond. And you might ask, what would keep somebody from being approved? It's basically in my experience, like a credit check. So if they're not credit worthy, they may not be bondable. So just be aware of that before you start down this road. So you might want to either have another heir that is bondable to be appointed, or you might want to start thinking about third parties that everybody can agree to. So let's see here. Now, another downside of a dependent administration is there's a lot of court oversight, meaning, yeah, you file an inventory, but after that, you're still on the hook. You still are accountable to the court. You have to file annual accountings. When you finish, you have to file a final accounting. But on the other hand, there's some protection afforded there. So if there's property that needs to be sold, the administrator is going to have to file an application with the court to ask the court if it's okay to sell this property. And the court will the court will allow people to come forward and object to that. And if they do allow the sale of property, they will make sure that the bond is sufficient when that that dirt or that house is converted into cash. It's hard to pick up a house and steal it, but it's a whole lot easier to take cash. So they want to make sure that your bond is sufficient. So with that, it provides a lot more protection to the heirs, but that comes with a cost, meaning it can be expensive. In my experience, it's roughly 2 times the cost of an independent. That's anecdotal, but that's been my experience. So if you can avoid a dependent, do it, but sometimes you can't. And, the funny thing I've learned over the years is I can't control the facts of a case. I can only control how I try to apply the law to those facts. and understand what tools are available to me. And if I can't get all the heirs to agree, or there's a situation where they can't agree, like there's a minor, there's nothing I can do about that. I've just got to move forward and do the best I can for my client. So sometimes, as much as it pains us, we have to do a dependent administration. Now, so let's talk about affidavit of heirship. Now, here's the difference between a determination of heirship and an affidavit of heirship. An affidavit of heirship is not a court proceeding. So it doesn't have it hasn't been scrubbed by a judge and an attorney ad litem for unknown heirs. It's a document that generally your client and the heirs and two disinterested witnesses sign and file in the deed records. Again, it requires two disinterested witnesses. This is under 203A2 of the Estates Code. Here's the rub about an affidavit of heirship. An instrument containing the statement has been of record for 5 years or more in the deed records of a county in the state in which the property is located. Basically, what this means is up until 5 years, an affidavit of heirship gets the side eye from everybody, and especially a title company. Again, in my experience, everything I'm telling you is worth what you're paying for it, which I think the price of admission today was $0. In my experience, if someone's been dead less than a year, title companies are loath to accept affidavits of heirship. After you get beyond a year from the date of death, they become more and more likely to accept them, and they become a non-issue after 5 years. So title companies are like judges. They can do whatever they want. They set their own rules. They're the king of their own kingdom, the queen of their own kingdom. You're just stuck with what you're stuck with. I have been known to title company shop before, trying to get a better answer from a title company. But the bottom line is, if it fits the facts of your case that your client's bringing you, and generally an affidavit of heirship is going to work when the only asset at hand is real property. So somebody comes in, everything else, and I should have mentioned this before, none of this is ever perfect. And generally when somebody comes in, they have a mixture of non-probate and probate assets. And so if you have a scenario where everything was non-probate, it was handled without the court needing to be involved, and all you have left is a house, and your client feels comfortable, doesn't need to sell it immediately, and just wants to make sure that ownership is done properly, you can consider an affidavit of heirship under 203. Again, though, it's going to have to be signed and executed by two disinterested witnesses, which sometimes are harder to find than others. But these are like, affidavits of heirship are like wine. They get better the older they are. So that, again, think of this as just having a toolbox. You've got a bunch of different tools in your toolbox, and depending on what the facts are that your client brings to you, you just reach in and grab the appropriate tool. So this brings us to the small estate affidavits. So this is filed with the court. Wait, let me back up. So hopefully that answered the question about the difference between a determination of heirship and an affidavit of heirship. One is judicial determination of heirship. One is non-judicial affidavit of heirship. So now don't confuse that with the small estate affidavit, which it has the word affidavit in it, but it's still judicial. You file it with the court. It's under section 205 of the Estates Code. It cannot be used if there are non-exempt assets that exceed $75,000. Again, it requires two disinterested witnesses and all of the heirs to sign. It does not create an administration. It merely passes title to the assets. Some courts will only approve a small estate affidavit when there's no real estate involved. Check your local listings. There is a really great if your facts lead you to a small estate affidavit in Dallas County, there's a really great little packet. I shouldn't say little, a great packet that Judge Monroe has put together that's available on the Dallas County Court's website that pretty much dummy proofs an affidavit of airship. This could be a really good option. Generally, this option comes up when the last time I used this, golly, this was horrible. Lady comes to me. She was initially my client because her husband died. And we were doing dad's probate, and then son dies, and he had about $20,000 at Bank of America that didn't have a beneficiary, wasn't a joint owned account. So we used a small estate affidavit to transfer that bank account to her son's heirs. So it is a great tool when the facts support it, but I'll tell you, it's a horrible tool when the facts don't. And if you have questions about it or don't understand it, download that packet that Judge Monroe did, then just follow what he says and you'll get what you're looking for. So now here's another hybrid. It's under section 451. It's a determination of heirship and order of no administration. Hold on, we got a question. Golly, a recommended form book. Well, the Dallas Bar, the probate section of the Dallas Bar has a little book. It's not a little book, but they have a book that has all the forms and everything you need to practice in this area of law in Dallas County. So hopefully that answers that question. You can reach out to, I think DVAP might have information about how to get your hands on that, and I'm sorry for this. Right now I'm drawing a blank. The only person I know, go ahead, Kristen.
I cannot think of the person to reach out to off the top of my head, but if you contact Maricela at the end of this program, we can get that information to you. And also, if you take a probate case through DVAP, you can get the Dallas County Probate Manual for free. So that's a great incentive to take a case.
Otherwise, it's like $120.
Something like that, yeah.
So it's called the Probate Manual. It's all coming back to me now. It's been a few years and a few gray hairs since I was chair of the section. But one of the great joys of being on the probate council is at some point you get the opportunity to be the person in charge of the probate manual, including making sure all those sales are done. I hate to do this. The only name I can think of somebody who's on the current probate section council is David Mead. But again, if you take a DVAP case, they'll get you one for free. It's worth it. It's worth $120 as well. It's got every form you would need for Dallas County. It's got the best thing it's got, in my opinion. It's got a little chart where they're asking a bunch of different questions to each of the judges, and you can kind of, it's like a scouting report for each court, how each court does each little thing, and you can kind of understand what you're looking at and what they're looking for, more importantly, before you get in front of them. That's called the Probate Manual from the Probate and Estate section of the Dallas Bar. Let's see here. Yeah, I don't know when the next edition will come out, Judge Monroe. That's a good question. You used to, I'm an old guy now. Back in my day, every time the legislature met, a new one came out. So I don't really know what the new procedure is. Maybe there's a member of the council on here that can answer that for us. All right, so determination of heirship and order of no administration. So you're not comfortable with affidavit of heirship, but you don't need an administration. So what you do, you file a pleading with the court, and it's completely discretionary if the judge wants to do this or not. But it's kind of think of it like a add-on to your determination of heirship. If you just want to kind of gild the lily on your determination of heirship and get a order that says, hey, we determined the heirs and there was no necessity for administration, you can do this. The issue here is it's up to the judge, and sometimes some judges will make you file what's called an affidavit of assets that'll show that there are no assets that need to be administered before they'll give you that order. But it's just one big, in your judgment determining heirs, it just says, and there's no necessity for administration, which can be helpful. So now the reason these are at the back towards the end of the presentation, they don't come up as much. I just like to throw them out there. I'm just going to breeze over these real quick. You can refer back to these as you need them. Section 451, application for a family allowance and order of no administration. It provides that the court can dispense with administration if the decedent is survived by a spouse, minor child, or adult incapacitated child, and the value of the estate not exceeding the homestead exempt property does not exceed the family allowance. Then no administration is necessary, right? If the allowance eats it all, there's nothing to administer. Let's see here. You can do an administration of community property under 453. It permits the surviving spouse to administer the community in both testate and intestate situations, provided no personal representative, easy for me to say, has yet to be appointed. It's also often called an unqualified community administration. Again, this is another tool in your toolbox. It doesn't come up often, but it's there if you need it. I like this one, access to an intestate account with a financial institution under section 153 of the Estates Code. If someone dies without a will and they own a bank account and the funds do not pass to another person, an interested person may apply to the court for an order requiring the financial institution to reveal the balance. This is helpful because a lot of times I'm sitting there in my meeting going, well, can I do a small estate affidavit? Does this fall beneath the threshold for that? Is it so much that I need an administrator? What are my options here? And sometimes banks are cool. They'll just tell you. And now you can say, no, you have to tell me. And so that's a nice tool to have. Now, here's the question. Who gets what? This is called intestate succession. So if someone dies without a will, the state of Texas has a will for them. The laws of intestacy dictate what heirs get what and what kind of property. And that's written out under Chapter 201 of the Estates Code. So if you're someone unlike me who can read those words and have them make perfect sense to you, God bless you. Or if you're like me, let me see. I want to make sure this gets shared. Hold on one quick second. Make sure I'm sharing the right screen. There's this awesome little chart that has been making the rounds for many years. I'm a visual person. This chart basically takes all of those words under 201 and puts them into a cool little chart, depending if someone was married or not married, if they had children from the marriage or not children from the marriage, if they weren't married, didn't have kids, blah, 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 blah. So keep this handy. This would probably be in the front cover of your probate code. So I won't explain any of that to you. That's self-explanatory. You can go look at it later. But you can see that either you can read the words under 201 or you can look at that handy dandy chart. There's the chart again. I forgot it was in there. Again, it covers all the different kinds of intestacy, how you were coupled, if you were married, unmarried, whether you had kids or didn't have kids, whether one of your parents alive or none of your parents are alive, you have brothers or sisters, and God forbid you die and you don't have any of those people, we end up in the dreaded moiety. This is under 201.001. And moieties are the bane of my existence. So basically, someone dies, they don't have a spouse, they don't have kids, they don't have living siblings, they don't have living parents. So now what we have to do is we have to split their estate in half. And it's called, each one of these things is called a moiety. You have a paternal moiety and a maternal moiety. And basically, the easy way to put this is you just go up to grandparents, great-grandparents, and then go out until you find living cousins. And sometimes this can be easy. It can be first cousins. Sometimes it can be hard. It can be 15th cousin 17 times removed. And this is where the hiring of a skilled and qualified forensic genealogist can be helpful, because once you run out of people that are close to the decedent, this gets really difficult to prove. And you want to talk about trying to find disinterested witnesses. Good luck. You can't even find anybody alive that was ever related to them. That's not, 5 people over on a depth chart. If you've ever heard the phrase laughing heir, this is where this comes from. You're sitting there minding your own business one day, you get a letter that says, hey, we've got $250,000 for you because your 12th cousin died. You've never heard of that person. You've never heard of the people that those people are related to, and you're going to pocket $250,000. That's a laughing heir. So just tuck this away if it ever